Hi, Attorney Bill Bronchick here, and I'd like to dispel a myth that has been running around on social media and in the investor community that taking a property subject to a government insured or guaranteed loan, i.e., FHA or VA loan, is illegal. It is not. Those loans are not government loans. They are private loans from banks that are either guaranteed or insured by the federal government because, frankly, who would do a zero down loan to someone with low FICO scores or a 3.5% loan in the case of FHA to someone who's got poor credit? So the government steps in and says if those loans go bad, we'll guarantee them. Now, a lot of title companies and even attorneys and brokers have been brainwashed with the idea that it is a federal crime to take a property subject to an existing government loan. Well, the question I always ask these people is, what law is that? There is no federal law that says anything of the kind. In fact, there's no state law in any state that says taking a property subject to an existing loan is illegal either. In fact, the federally promulgated HUD-1 closing form has a line in it that says subject to existing loan. Why would the federal government promulgate a form assuming subject to if subject to were illegal? So it makes absolutely no sense. Now, the practical effect of this is a lot of title companies are spooked by this rumor going around about it being illegal to do a subject to on a government insured loan, and most of them won't do it. Now you have to decide at that point, if you can't find an attorney, escrow, or title company to close it, would you close it without title insurance? And there is a risk in that if there are title problems that come up later that you were unaware about. But think about the risk. If you were buying a property subject to an existing loan, let's say a VA loan, which has a balance of 180,000 and the property's worth 200, and you give the seller maybe $3,000 walking money, what is your risk? Your risk is $3,000. And if all you do is rent the property and it turns out there's a title problem later that's unfixable, well, you just continue to rent it and you don't sell or refinance the property. So again, there is no law, there is no court case, there is no statute, there is no ordinance anywhere that says taking a property subject to a federally insured or guaranteed loan is a federal or state crime. That is an old wives' tale. It is a myth. And I challenge anyone to come up with a law that says otherwise. And if anyone ever says to you in real estate or in your business in generally, well, that's illegal, ask them, what law are you referring to that makes what I'm doing illegal? And usually you'll get a blank stare in response. Bill Bronchick, I hope you've enjoyed this video.